Start. Heard Shri Anup Trivedi, Learned Counsel for the Appellant, and Shri Anand Prakash Srivastav, Advocate, holding brief of Shri Anshuman Vidhu Chandra, who is also present, along with him, Learned Counsel for the sole respondent full stop para. This content appeal has been filed against the order dated 28/5/2018, passed in contempt application civil number 2203 of 2018 in bracket Tolan Singh at the rate Vijay Bahadur Singh versus State of UP and others bracket out under section 19 of the Contempt of Courts Act 1971, wherein prayer is made to set aside the order dated 28/5/2018, passed in contempt application number 2203 of 2018, and consign the contempt petition to record full stop para. The submissions made in the memo of appeal are that the writ number 17471 of 2016 in bracket Tolan Singh at the rate Vijay Bahadur Singh versus State of UP and others bracket out was disposed of wide order dated 17/4/2017 with a direction to the district magistrate to examine the original records, keeping in view the law laid down by division bench of this court in case of Shivram Singh versus State of UP and others full stop. This court had also referred in the said order to the law laid down by the Honorable Apex Court in the case of State of Assam versus Bhaskar Jyoti Sharma in bracket 2015 5 SCC 321:2015 in bracket 2 AWC 2118 in bracket SC full stop. The said contempt petition number 2203 of 2018 was filed alleging that the opposite party in the contempt petition had not passed any order on pursuance of the writ court's order dated 17/4/2017, and the same was still pending, although in compliance of the said order dated 17/4/2017, the appellant had already passed an order on 23/1/2018 rejecting the claim of the writ petitioner. Therefore, the said order dated 17/4/2017 of the writ court had already been complied with full stop. Thereafter, the contempt court passed an order dated 28/5/2018, impugned order, whereby the appellant was directed to file his personal affidavit observing as follows: from the instructions placed on the record today, which for the purposes of identification are marked as X, the court notes that the collector states that there is no record or evidence of the alleged transfer of surplus land to the Allahabad Development Authority full stop. The court finds itself unable to appreciate the stand so taken by the collector, since if there were no records of a transfer to Allahabad Development Authority, then recital to that effect could not have possibly appeared in his order of disposal full stop. The court is further constrained to observe and note that in the order of disposal passed by the collector, the stand taken is that the land had been transferred to the authority prior to the promulgation of the 1999 Act and the appointed date prescribed thereunder full stop. This positive recital is not explained even today, nor does the collector rely upon any evidence in support of this proceeding full stop. In fact, and to the contrary, the court notes from the instructions provided by him to Shri Upadhyay today that he admits that no evidence or material of the transfer of possession exists. Full stop. The court also takes note of a decision rendered by a division bench of this court in Lalji versus State of UP 2018 in bracket 5 ADJ 566, in which to the stand taken was that the land had been transferred to the Allahabad Development Authority prior to 18th March 1999, the cut-off date as prescribed under the 1999 Act. Full stop. Even the division bench had found that no material existed or was brought on record to establish a transfer of possession in light of the statutory provisions. Full stop. The court further notes that apart from the above, the collector alludes to no other material to establish that the land is in the possession of the ADA. It is evident that the disclosures made by the collector Allahabad have been less than candid and prima facie are not borne out from the record. Full stop. Para. Consequently, the opposite party shall file his personal affidavit and explain why further action be not taken against him. Full stop. Para. Thereafter, the appellant constituted a committee of 4 officers to submit a meticulous report, and after thorough examination of the entire record, the committee submitted its report on 13/7/2018, clearly negating claim of the petitioner, and on the basis of record, an assessment/evaluation made by the committee, the appellant proceeded to test the facts of the case in the light of judgment of the Honorable Apex Court in the case of State of Assam versus Bhaskar Jyoti Sharma, as well as that of this court's judgment in Shivram Singh's case, and thereafter the appellant passed an order dated 13/7/2018 rejecting the claim of the petitioner. Full stop. Further, it is mentioned that the said report of the committee, the documents relied upon by the committee, and the order passed by the appellant had been brought on record in the contempt proceedings. Full stop. By means of an affidavit of the appellant dated 15/7/2018, but when the matter was taken up and on 16/7/2018, the contempt court observed that till the order dated 28/5/2018 holds the field, the stand taken by the appellant while rejecting the claim of the petitioner could not be accepted, and hence granted liberty to the appellant to file a review petition for getting the order dated 28/5/2018 reviewed. Full stop. Further, it is mentioned that thereafter the appellant sought legal advice, pursuant to which he challenged the order dated 28/5/2018 passed by the contempt court on the grounds that the order of writ court dated 17.4/2017 stood complied with the moment the district magistrate Allahabad had passed the order after examining the records of the case. Therefore, the appellant had already complied with the order dated 17/4/2017 of the writ court rejecting the petitioner's claim. There was no reason left for drawing the contempt proceedings, as he had already passed order dated 23/1/2018. Full stop. Over.